We'll first have Janet Kiptanui, a member of the Endorois community and the Endorois Welfare Committee, who will then speak to us about who are the Endorois people and why did they go to the African Commission and what was the result. So we will want to hear from an Endorois community member on their experience in that regard. Then we are going to have Andrew Songa from AU, from the FIDH, who is a FIDH delegate to the African Union. He's been engaged in matters of indigenous peoples for a long time, first with Semiride, then at the Kenya Human Rights Commission as a staff there working on indigenous people's issues and other issues, but also in the context of transitional justice in which Andrew Songa is also an expert in. And Andrew Songa is going to give us experiences, lessons learned in litigating the Endorois decision at the continental level, and then the lessons learned in following up the implementation of that decision. Then finally, we are going to have Cyrus Maweu, who is a staff of the Kenya National Commission on Human Rights at the Kenya's National Human Rights Institution, which has been intimately involved in following up and monitoring the implementation of the Endorois decision in its role as a national human rights institution, but also in its capacity as a member of the task force that the Kenyan government established to follow up and see into the implementation of that decision. So that gives us really a good picture through these three panelists on what has happened 10 years later after the adoption of the Endorois decision. We'll then at this moment go to Janet Kiptanui to speak to us about the Endorois people and the case that they took to the African Commission. Janet, over to you.
Endorois community normally live in Baringo County in two sub-counties, Mogotio and Baringo South. In 1995 until 1996, we were chased out of our homeland, which is surrounding Lake Bogoria, by the government led by a former president, the late Troitich Arap Moi. But the community resisted the act and fight and struggle against their land without any success, even after petitioning the government. And that was the time they decided to go to Africa Commission in 2003, in May 9, 2009, at Kibaki's leadership. Up to date, no implementation at all. The Endorois community struggled all those times since 2019 to 2009. Up to date, no implementation at all.
Okay, thank you, Janet, for that brief description of the reasons why the Endorois community approached the African Commission, and a brief line on the status so far on the implementation of the decision, which I think also Cyrus will be speaking much more in detail. And I think now this brings us to Andrew Songa, who, as I initially said, was engaged at the beginning of the litigation of this process and later in following up and monitoring implementation. So Andrew will be speaking to us about the lessons learned, the approaches, the tactics that were used in litigating this case, and what can be lifted for other similar cases for indigenous peoples across the continent. Andrew, over to you.
Thank you very much, Japheth, and I'm happy to have the opportunity to be able to reflect on this, one of these seminal cases for the African Commission, as you had highlighted, setting down the yardstick for indigenous people's rights and becoming the platform through which other communities, even in Kenya, such as the Ogiek, were able to then even proceed and take further strides within the African court and continue to solidify the rights for indigenous peoples, not just in Kenya, but in Africa, as we then saw, as you mentioned, with the work done by the working group on indigenous populations in Africa. So as you've mentioned, I will try and tap into some of the experiences I had with one of the institutions that filed this case alongside the Endorois, and that is the Center for Minority Rights Development, and just try to highlight some of the key lessons that emerged from the process of bringing the communication to the African Commission and what it took to do that and mount that level of litigation and get that unprecedented decision, and therefore reflect somewhat on implementation, but not delve too much into that because I understand Cyrus will speak to it. So to begin with, I would want to put this discussion within the setting or the framing of looking at the Endorois case as one of strategic litigation within the rubric of the concept of strategic litigation. And I will just borrow from the definition of the Open Society Justice Initiative that had done a study around strategic litigation impacts, where they define strategic litigation as legal action in court that is consciously aimed at achieving rights-related changes in law, policy, practice, and or public awareness above and beyond the relief that you actually acquire for the plaintiffs listed in the case. And what does this mean? At its best, strategic litigation will therefore not only yield material benefits for the complainants in the case, it will proceed to trigger progressive legislative and policy reforms alongside the jurisprudence that is generated, and also occasion a change in public attitudes with regards to the issue that is litigated on. At its worst, public strategic litigation then can be a very time-consuming, frustrating exercise, and also maybe even the cause for backlash against the group that is seeking redress. And it can also be very ineffective towards reform. So it's within that shape that I would want us to think through the experiences we will hear today about the Endorois case. With that framing in mind, I will speak through about 10 key points, I think, that we can reflect on with regards to the litigation for the Endorois case. And the first one, I think Janet sort of introduced it for us, and it's that the journey for this litigation doesn't begin in the courtroom, but it begins with the community's articulation and assertion of its rights. And so she mentioned how, for example, the community centered its claims around the fact that they had been displaced from their ancestral lands, and that displacement had caused damage of property, disruption of their way of life in terms of pastoralism, disruption of their religion and culture, as well as the overall development of the community. And that this happened against the backdrop of the community constantly making demands of the state, trying to negotiate with the state, and also experiencing broken promises from the state as they tried to fight for a reclamation of their ancestral lands since 1973. But what do we learn from that arc? I would hope that some of the key features in terms of focusing on communities asserting their claims are three things. The first is that there has to be clarity within the community in terms of what their grievances are, the harm they have suffered, and what their desired remedy is, essentially their ask. The second key element is cohesiveness. It is very important to have a community that is unified in its cause. And that means having very inclusive processes of effective participation, consultation, and informed decision-making about how the community wants to pursue and claim its rights. And then thirdly, it's about resoluteness of the community, that even in the face of threats and intimidation, the community can stand firm, that it can have leaders who will stand steadfast and continue to assert those claims and those rights. I think within the Endorois case, as you think through the experiences, these were three important elements that reflected themselves first within the community leadership itself, and then what was eventually organized and constituted into the Endorois Welfare Council. Secondly, it is also important to appreciate the context that informed the case. That beyond the direct claims made by the Endorois, these claims were situated within wider concerns of indigenous peoples in Kenya. And essentially the core of these concerns were that prior to 2010, we did not have constitutional recognition of indigenous peoples in Kenya. What we did have was some policy statements and referrals by the government that would concede that they were communities that were either collectively branded as minorities, marginalized, or vulnerable communities. Specifically, a 2007 report by the UN Special Rapporteur for Indigenous Peoples after a visit to Kenya kind of encapsulated the concerns for indigenous peoples in the country into about 4 key areas: that they lacked legal recognition and empowerment, which again caused social, political, and economic marginalization; that they continued to suffer the ramifications of the loss of and environmental degradation of their land, primarily as a result of conservationist policies utilized by the state, which in turn violated the economic, social, and cultural rights; and that they also had an absence of social and health services within indigenous communities, which disproportionately affected their women and children and accentuated the discrimination that they endured with regards to the rights to property and as well as harmful traditional practices. But also importantly, the Special Rapporteur underscored the fact that the lack of transitional justice and redress mechanisms impacted on the human rights of indigenous communities. So we were working in what was essentially a very hostile environment for the furtherance of indigenous people's rights in Kenya. And that takes me to the third point, that once it was clear that there are claims the community has held on to and rights that they wanted to assert, and that we are aware we were in a hostile environment, it was still important to effectively engage with the domestic legal process and exhaust domestic remedies. And what did that then mean? That culminated, okay, as I mentioned, there were attempts at amicable settlements with the government, attempts to have conversations with the state, including with the president, who happened to be the member of parliament for the Endorois, in the sense that the Endorois fell within the president's constituency. But despite different undertakings given by the president, their grievances were not addressed, and I characterized them earlier as broken promises. So this led to embarking on litigation in the Kenyan High Court in 2000, as Janet mentioned. And this proved futile because the court didn't really engage with the substantive aspect of the Endorois claim. They knocked it off on technicalities, remembering that Kenya's Bill of Rights at the time was an individualized Bill of Rights, and that we also had a procedure of appropriating lands for indigenous peoples within what we call the trust land system that had been utilized to take away Endorois land. So rather than engage with the substantive elements that the Endorois had questioned with regards to the aspect of whether or not the trust land procedure had effectively extinguished the ancestral claim of the Endorois to their land, or whether even in fact the procedures were properly followed, the court didn't engage with those substantive issues and dismissed the petition. The community then sought to appeal that decision before the Court of Appeal, but that appeal was actually frustrated by the inefficient judicial system in the country. They had to wait an inordinate amount of time for the record of appeal to be drawn up and filed, and that in its sense frustrated the prospects of appealing the High Court decision. So that takes us to the fourth element. If you then find you have been frustrated by the domestic system, then you turn to the regional African human rights system. And that's how the community turned to the African Commission on Human and People's Rights. And essentially, this was for two core reasons. The African Charter provided an avenue for protection, both in terms of substance and procedure. In terms of substance, I mean the rights enshrined in the African Charter acknowledged essentially what would be indigenous people's rights. The right to culture, the right to religion, economic and social and cultural rights, the right to property as conceived by the Endorois. This contrasted against a prevailing Kenyan constitution that did not provide for all this ambit of rights. And then the second one was procedural, acknowledging the fact that the commission would acknowledge the non-existent of effective, available, and efficient remedies, recalling what I just mentioned about the High Court and the Court of Appeal. and that also the very nature of the procedure of the African Commission was less restrictive in comparison to the Kenyan one. By that, I mean, it had an expanded understanding of who had standing to come before the commission. So as you've seen within the case citation itself, you had two non-governmental organizations, Semi-Right and Minority Rights Group International, coming in on behalf of the Endorois community to litigate against the state of Kenya, against something that would not be possible under the prevailing constitutional context at the time when the Endorois case was filed. So once we were now in the commission, the important lesson that emerged, that now you are arguing your case, is the importance of a merits argument that is backed by strong and innovative evidence. And I think three highlights but would illustrate this. The first is the Endorois case drew in the unprecedented move to allow video testimony within the proceedings of the African Commission. And this was the documentary that had been prepared by the community in conjunction with Semi-Right and Witness that was called The Rightful Place. And just to quote one of the litigants of the case in reflecting on this innovative aspect, they referred to the documentary as having brought the voices of an oppressed community into the hall of justice and strengthened the reality of the indigenous struggle in Africa. So that becomes another thing of ensuring that one of the core elements of arguing your case and putting forward evidence is accentuating the voices of the victims as being at the heart of the argument. The second aspect of innovation with regards to evidence was the utilization of expert testimony to underscore the frailties or the deficiencies and landscape of Kenya's land law. And again, this was done by bringing in one of the leading experts at the time of Kenya's land law, the late Professor Okoth Ogendo, who was very instrumental in unpacking the concerns of the Endorois vis-a-vis the trust land system that was used to appropriate the ancestral lands. The third element was also the utilization of amicus briefs. And in this context, the Center of Housing for Rights and Evictions offered an amicus brief to aid the main arguments of the complainants in the case to illustrate the harms caused by the evictions that had been undertaken by the state. So essentially broadening the constituency of allies in terms of pushing the case forward. The sixth element is being alive to the contemporary developments and sustaining a strong advocacy strategy alongside the case in anticipation of the implementation phase. Now, the Endorois case is very interesting and somewhat unique because of the fortuitous convergence that happened between the delivery of the Commission's decision and the fact that Kenya was in a transitional period where we then saw certain elements of reform take hold. So it was very important to be alive to those developments because you're beginning to anticipate emerging frameworks that can work to the benefit of implementing the decision once it comes out. So I'll just give a few quick examples. As the case was going on in about 2006, the Kenyan government embarked on development plan, action plan, and policy on human rights. It's first, I believe. And so within that context and using the momentum of the arguments that had already been averred within the Endorois case, you then had a situation where non-governmental organizations such as Semi-Right were able to galvanize and make a very strong argument for having a thematic focus on minorities and indigenous peoples within that policy and ultimately being included in developing that said policy with regards to indigenous peoples. We had a constitutional review process that went through 2 cycles, a failed referendum in 2005 and then one that finally validated a new constitution in 2010. Within those contexts, this Endorois case had legitimized the claims of pastoralists and hunter-gatherer communities within that constitutional review process. And just to quickly cite some reflection on it, the impact of the Endorois decision on the constitutional review process can be seen as follows. That the Endorois decision became the rallying call in the context of the campaign for a new constitutional for a new constitution in Kenya. That the adoption of this new constitution, which has effectively abolished the trust land regime discussed earlier, created a new tenure arrangement based on communities constitutes one of the greatest policy gains for these communities in the country. The third example I will use is the Truth, Justice and Reconciliation Commission process that Kenya went through between 2008 and 2013. The Truth, Justice and Reconciliation Commission, the TJRC, in its final report in 2013, dedicated a specific chapter on minority and indigenous peoples. And within that, you will see that the Endorois case decision was pivotal to shaping the Truth Commission's definition and understanding of indigenous peoples. It also contributed to its findings, such as the fact that the state had failed to accord due recognition to minority and indigenous communities in Kenya, that the land tenure system had been hostile to these communities. And in fact, the Endorois case was used to illustrate that failure of the trust land system that I spoke to earlier. And that the infringement of the indigenous people's rights to development as informed by free, prior, and informed consent was also a key finding, and that was located within the Endorois case decision jurisprudence. The commission also went to explicitly highlight as one of its key recommendations that the government needed to implement the decision of the Endorois case. Finally, with regards to advocacy, is also the fact that we were able to effectively utilize the spaces of various UN platforms to advance the cause of the Endorois case that had been litigated in the African Commission. So like within UNESCO, the World Heritage Committee reviewed the status of Lake Bogoria and issued a state of conservation report, which required the Kenyan government to report on the conservation of the lake and urged the Kenyan government to include the Endorois in the management and benefit sharing of the resources accruing therein. And that the case has also featured prominently within the concluding observations of various review platforms, like the Human Rights Committee, like the Universal Periodic Review, and the Committee of Economic, Social, and Cultural Rights, but to name a few. It is also very important, as a lesson to reflect on, that meticulous documentation of your engagements with the state, as well as being proactive and tenacious in updating the African Commission with regards to those engagements, that is an asset to progressing the case. And what does this mean in the Endorois context? The fact that there was continuous correspondences and check-ins, especially after the decision was issued, to require the state to act, enabled us to secure one of the very rare occasions of an implementation hearing before the African Commission under the previous rules of procedure, Rule 112. And it is through that implementation hearing we were able to then procure from the Commission Resolution 257 of 2013, calling on the Republic of Kenya to implement the Endorois decision. Getting to that milestone of the resolution that explicitly called out the Kenyan government, it took a lot of sustained engagement since 2010 when the decision was issued. Looking for every single opportunity to engage with the Ministry of Justice, ask them about a roadmap for implementation, engaging with the National Human Rights Institution, the Kenya National Commission for Human Rights, enlisting them to support the push for calling on the government to trigger a roadmap for implementation, going into the successive ordinary sessions of the African Commission and updating the Commission on the lack of action by the government or clarifying certain steps the government had made. And we did this through oral statements. We did this through written correspondences. All this was very effective in keeping the case within the radar of the Commission and also within the radar of the state itself. I think as I conclude, is to say that if you take all these different steps into context, and I will reflect on implementation after me, litigating within the African human rights system enabled the Endorois to challenge a state that was intent on limiting the scope of rights and justice. In doing so, they challenged what was the prevailing social contract and obtained jurisprudence that was then of benefit to the wider constituency of indigenous peoples, recalling the objectives of strategic litigation I had mentioned earlier. That they had then gotten protections under the that were not immediately available within our prevailing constitutional framework at the time. that the case inspired transformative aspects with respect to Indigenous people's rights, as I've mentioned in our current 2010 Constitution and in the final Truth Commission report. And that these processes affirmed and validated the claims of Indigenous peoples and maintained or renewed an impetus for redress, that now other communities could now stack onto that and make their own claims. I do recognize that we are going to discuss the fact that implementation in the substantive sense or the material benefits for the Endorois has not really happened. And we have seen also checkered implementation of some of the reforms I've mentioned. Our constitution is there, but we've not really seen the true fruits of some of these provisions with regards to community land, for example, or with regards to addressing some of the aspects of marginalization for Indigenous peoples, because the environment still remains hostile politically. But despite these setbacks, the Endorois case does show us that Kenya's Indigenous peoples, through the experience of this litigation, do bring with them valid assets for the next phase of the struggle. And that is how I will conclude. There is now an enhanced legal and political empowerment from engaging in the litigation and transitional justice processes I mentioned, which came up in the country. There's an evolved network of solidarity at the national, regional, and international level for these communities. You know, with the case started without a registration of an Endorois Welfare Council, it concluded and swiftly we saw an Endorois Welfare Council, but then we also saw a lot of galvanizing and organizing amongst Indigenous peoples to the point where we have forefront civil society organizations representing Indigenous people's rights in Kenya and consciously organizing across a variety of issues. And that also there's a civic awakening and potential for generational transfer of the mantle of this cause to a future re-energized generation of activists within the Endorois community and beyond. And that is to say, this case started with a set of community leaders and elders, but even as we've moved through that long journey from 1973 to the 2003 case decision to the 2010 decision and its implementation, we've seen a succession of leadership, an emergence of new leadership, but a sustained call for the Endorois claim, the Endorois demand for its ancestral land, and hopefully that will continue to reinvigorate itself, revive itself, and sustain what was a journey that started very, very, very long ago. I think I'll close with that, Japheth, and thank you all for your time.
Thank you so much, Andrew, for that really elaborate and comprehensive journey from the lodging of the case to how the case was litigated, to the high points, the new innovative ways of presenting evidence, to following up in terms of the implementation, Resolution 257, the implementation hearing. In a sense, the Endorois decision has had so many firsts and has introduced so many procedural innovations within the African Commission. And this now actually particularly reminds me that one of our participants is Dr. Feyo Gunade, whom, as some of you may know, participated actually in the writing of this decision to go together with Dr. Robert Eno, who is currently the Registrar of the African Court on Human and People's Rights. At the appropriate time, Faye, I'm afraid you will not be able to escape. I'll give you an opportunity to speak about the experience of receiving this case and writing about it, and what are your thoughts 10 years later, given the labor of love that you gave to this particular decision. But for now, I would like to invite Marie. We are going to screen a short video for us to watch on the Endorois community. Marie, over to you to show the video.
So I'll show the video in English, although I'll share links in the chat box for the other languages.
naitwa Janet Kiptanui. Mimi ni mama kutoka jamii ya Endorois. Mimi ndio nimechaguliwa kusimamia kama mwenyekiti wa Endorois Indigenous Women Forum. Na sisi katika jamii yetu Endorois, sisi ni watu minority katika Baringo County. Tumefikisha almost 50,000 people. Na sisi tunapatikana katika Baringo, ambaye ni Baringo South Sub-County. Na sisi mbeleni kabla tulikuwa tunaishi katika Lake Bogoria. In 19th century since tumeishi Lake Bogoria, hapo ndio imekuwa nyumbani kwetu. Lakini miaka ambayo wakati mzee mstaafu Rais Daniel Toroitich arap Moi alipokuwa rais, tuliweza kutolewa katika lake, tukafurushwa, tukaambiwa tuende tuishi sehemu za highland parts of Mochongoi. Tukaweza kutolewa wote katika lake, ndio waweza kufanya conservancy, waweza kuweka wanyama, waweza kufanya kama mahali pa wildlife. Sasa tulitolewa bila kukuwa na compensation, bila serikali kujali ni tutatoka na tutaenda kuishi aje. Tulitolewa tu kwa lake, na hapo tulikuwa tunaona kama ilikuwa ni changamoto kwetu sana. Sasa sisi tuliweza kupigania, tuliona si haki, na tuliweza kustaki serikali. Waliweza kuconserve the lake, lakini wakatutoa bila kutuhusisha bila kujali vile tutaenda kuishi, bila compensation, na hapo ndio ilikuwa nyumbani. Sasa tukaweza kuenda katika court la Kenya kusema sasa, yani kulalamika juu ya haki zetu, lakini haikufua dafu. Sasa ndio sisi tukaonelea kwamba tutaenda African Commission, ndio at least pengine maombi yetu ama matakwa yetu itaweza kutekelezwa. Ilikuwa ngumu kwa sababu tulipopigania haki zetu, kustaki serikali kufanya haya yote, kufanya maandamano, ndio serikali waweza kutusikiza. Ilikuwa ni vita. Hata watu wengine walikosa, hata walikuwa walimu, walikuwa maaskari, walifutwa kazi. Wale walijulikana walikuwa wanahusika na kusaidia jamii kwa kutetea haki zao. Hata wengine wali lose mali mingi kwa sababu ya hiyo kufurushwa, maybe kushikwa, kwenda gerezani wengine. Haikuwa rahisi. Kama sisi wa mama, hatukuhusika kabisa kuja kibao mbele, lakini sisi ndio tulikuwa tunaleta chakula kuwapelekea wale wako msuni wanajificha. Sisi ndio tulikuwa tunaweza kuficha siri, kwa sababu serikali ilikuwa kali sana. Ilikuwa inakuja, wanapiga watu, wanasema mtoke, hata tunachomewa manyumba. Haikuwa rahisi, ilikuwa ngumu sana. Kwanza kabisa, naona impact ambayo imetuletea, kwanza ni tumepata sifa, kujulikana ulimwengu, karibu ulimwengu mzima, Kenya mzima, na community zote, tribes za Kenya wamejua kuna watu wanaitwa Endorois, na walipigania haki yao kwa Kenya. Haikufua dafu, wakapeleka African Commission, na ambapo hapo ndio tuliweza kushinda kesi. So hiyo impact ya kwanza ni hiyo, tumeweza kujulikana kama community. Lake Bogoria iko na pesa. Sisi sasa kama community ya Endorois tumeweza kupata 10% of the revenue ambayo county government ya Baringo inapata. Hiyo inakuja kwa community. Tunafanya mambo zetu kama kusomesha watoto wetu, na pia hata kutengeneza projects. Katika nafasi za kazi, watoto wetu wamekuwa benefited. Tumesema hiyo ni haki yetu. Kama kuna watoto wanaandikwa kwa revenue, kwa nini, kwa clerks, lazima wakuwe na watoto wa Endorois, kwa sababu sisi ndio tuna own the lake, na tunaamini lake ni yetu. Hiyo ndio impact nyingine ambayo serikali wameheshimu na wameweza kutekeleza. Impact nyingine ni kuwa wakati yeyote kuna mambo wanaongelea kuhusu hii ziwa la Bogoria, at least wanahusisha kamati ya community pia. Wanaitwa kwa board ya county government, alafu waweze kutoa hisia na maoni zao kuhusu vile hata wao wangetaka kusaidiwa ama vile wangependa mambo ya lake iwe inasingatiwa. Sisi tunaona ni la muhimu sana isiguswe, isipinduliwe nini, ikae tu vile iko kwa sababu iko independent kivyake. Na sisi koti ya Kenya ikikataa kusaidia wananchi, sisi bado tutarudi tu pale pale. Na kwanza sisi kama Endorois tunataka ibaki kwa sababu already serikali ya Kenya bado haijafanya compensation kwa watu wa Endorois. Baada ya sisi kufurushwa kwa lake bado hatujapata compensation ya mali zetu ile iliharibiwa, ya vitu yetu ile watu wale walikosa kazi, bado kesi wanasema wata-implement lakini bado. So tunataka hii baki hivyo hivyo juu unasaidia mwanadamu yeyote wa Afrika kuweza kusikizwa haki zake.
Thank you, Marie. I think that's really quite an inspirational video profiling and hearing more from Janet. Thanks, Janet, for that inspiring video. Now we move to our last but not least presentation by Cyrus Maweu, who, as I initially said, is a Deputy Director and Head of Economic, Social and Cultural Rights at the Kenya National Commission on Human Rights, Kenya National Commission on Human Rights, which is the NHRI, National Human Rights Institution in Kenya. Cyrus is going to speak about and give us an update on the implementation of the decision by the government of Kenya, while highlighting the role of NHRI and civil society to work jointly to advance collective rights as enshrined in the African Charter on Human and People's Rights.
Thank you very much, Daktari. As already introduced, my name is Cyrus. I work with the Kenya National Commission on Human Rights, and I'm really very grateful to SIAC for this opportunity to participate in this very important discussion that is not only focusing on the Endorois decision, but broadly on the rights of indigenous people in Kenya. Watching that film and listening to Janet, I draw quite a lot of inspiration from that short film. The efforts and the struggles are clearly quite well documented. And I just want to say, before I go into the presentation, to Janet and other community members of the Endorois community, your resilience has really paid. We may not be where we wanted to be as a community or as a country, but your efforts have so far have quite some positive changes, even shaping the discussion around matters indigeneity and the rights of indigenous people in this country and in this continent. So by way of introduction, the Kenya National Commission on Human Rights is an independent national human rights institution. It's operationalized by an act of parliament, but is also entrenched in the constitution and is broadly mandated to perform two functions. One is a protective mandate by acting as a watchdog over the government in the area of human rights, and a promotional mandate by playing a key leadership role in providing advisory and moving the country towards a society that respects the rights of everyone. The Commission fulfills these two mandates broadly through a number of strategies that include the receipt and processing of complaints, research related to matters human rights, rendering of advisories, and also conducting public education and training on matters human rights, and more relevant to today's discussion, monitoring the state's fulfillment of its national, regional, and international human rights obligations. So just by way of background, the previous speakers have already spoken and gave the necessary background to the decision, or to what led the Endorois community to find their way to the African Commission on Human and People's Rights. And this was basically a decision by the government sometimes in the 1970s to 80s to evict them from what the community considered their ancestral lands around Lake Bogoria for purposes of conserving the area as a national reserve. The community was aggrieved that they were not consulted and they were not given any compensation despite their being evicted from the lands in question. Again, there was also the argument very strongly around the rights to culture and religion, where the community was claiming by being so evicted from the areas that they would practice their religion, this right was grossly violated. Having heard from the community through its representatives, which were supporting the community, basically the civil society organizations that were supporting the community in advancing its cause before the African Commission, the Commission was satisfied that there were violations of the African Charter on Human and People's Rights, and the Commission confirmed a violation of Articles 1, 8, 14, 17, 21, and I believe 22 of the African Charter on Human and People's Rights, which relate to the rights to property, the right to properly dispose of their wealth and natural resources, which in a way affects their right to development, and other rights such as the right to culture and to practice religion. Key among the findings was the recognition of the community as distinct and an indigenous community, contrary to the position that was taken by the Kenyan government before the African Commission on Human and People's Rights. Having made a finding and confirmed the violations I've just highlighted, the Commission made some key recommendations to the government of the Republic of Kenya, and this is what forms the basis of our assessment on the level of implementation. I will just highlight those recommendations, and key among them was the question of recognition of the rights of ownership to the Endorois community and restitution of the ancestral land that had been taken away by the government when the community members had been evicted from the ancestral lands around Lake Bogoria. The Commission made it very clear that the government has a duty to recognize the right to property of members as a community. The question around communality of ownership of the rights and the land in question. And to this end, the Commission recommended to the state that it should put into place mechanisms that would give recognition or a legal effect at the domestic level to these rights to communally own properties. Another very key recommendation was for the state to ensure that the community has unrestricted access to Lake Bogoria and the surrounding sites, and this would basically facilitate the observance of religious and cultural rights by the community that had been evicted therefrom. There was also the question of payment of compensation for the violations that had already taken place, and also the payment of royalties from existing activities. And the Commission went ahead to recommend that the local community should be considered in matters employment within the National Reserve. Without appearing to contradict, especially Janet, who at first took the view that nothing much has been done, I will just highlight some of the progress. We may not be where we wanted to be, as I had started by saying, but at least we should acknowledge that there's been some progress, maybe not strictly limited to the Endorois, but to indigenous people's rights broadly. The starting point is that at first there was quite a lot of hope because the decision was well received, and there was a very big celebration, one would say, in Lake Bogoria, and the chief guest was actually the then Minister for Lands, who gave commitment that the government not only welcomed the decision, but would be taking steps towards implementing the recommendations of the African Commission on Human and People's Rights. Despite that promise and the celebration, close to 11 years down the line, there isn't much to show in terms of implementation, although there has been some progress. And I will go through this in terms of the specific recommendations. If you look at the first one, the question of recognition, at least as of today, there was a recognition of the community. We also have a constitution that recognizes and appreciates the existence of indigenous people, and also the question of communal ownership of land by various communities. And actually, for the classification, it makes it very express that community land would be part of the lands that were previously or historically occupied by hunter-gatherer communities. And in the definition section, it defines indigenous people as part of the minorities and marginalized people. Again, the Endorois Welfare Council has been registered and has been formally recognized and has held periodic elections for its office bearers. I think the most recent was sometimes in 2019. On the question of recognition of the rights of ownership, this has not been fully done despite the passage of the Community Land Act. Very few communities have concretized and registered their rights or interest in land, and the Endorois community is not one among those communities that so far have legal ownership in the sense of having titles to specific parcels of land that can be said to belong to those communities. There was also the question of unrestricted access. This has not happened fully because the area is still categorized as a national reserve with very restricted access, which is controlled by the government, and the community does not have unrestricted access to the land in question. So there's been very limited implementation to that extent. On the question or the recommendation of the payment of compensation to the community, this has not happened. The community, as Janet has already highlighted and previous speakers have, they've not been compensated for the violations that happened. Lastly, on the question of payment of royalties to the Endorois community from existing activities and to ensure that they benefit from any employment opportunities within the reserve, this has partially happened. As Janet has already highlighted, the Baringo County government pays 10% to the community of the revenue that is collected from the operations of the National Reserve. Again, matters employment, I do not have the exact figures, but the Endorois community is not the most highly represented in terms of employment within the National Reserve. The African Commission had also recommended that the government of the Republic of Kenya should engage in dialogue with the complainant, being the Endorois community, to ensure effective recommendation of the recommendations that the Commission gave. Unfortunately, this didn't happen much. Sometimes in September 2014, the government set up a task force. This task force was meant to advise the state on what steps could be taken to facilitate compliance or implementation with the decision and recommendations of the African Commission. Unfortunately, the term of the task force came to an end without much having been done. And the community was also not represented in this task force. Again, finally, the African Commission had recommended that the state, being the government of the Republic of Kenya, should report on the progress of implementation within a period of 3 months from the date of notification of the decision and recommendation. This has not happened. To the best of my knowledge, no final report has been filed with the African Commission on Human and People's Rights on the implementation of this decision. The Commission, being the NHRI, has participated as having been acknowledged by the previous speakers in the implementation of this decision. And this we did through a number of activities that I will just highlight some. And you will realize that these activities were mostly done jointly and with the support of the civil society actors in the human rights sector within the Republic. One was a question of community sensitization on the import of the decision, and this was basically to promote public awareness on what the decision means for the country and for the community, and more specifically for other indigenous communities within the Republic. The Commission also convened different stakeholders, and this was basically to chart a way forward and formulate an implementation strategy. And in this convening, different civil society actors were brought on board to bring in their expertise and facilitate the exchange and sharing of knowledge on what best could be done to ensure that implementation was given a priority. The Commission also gave an advisory to the government on implementation of the decision, and also engaged different actors, especially experts, during the constitution making process to, among others, interpret the relevant clauses of the Constitution that relate to human rights and indigenous people, and also highlight best practices that could be borrowed to ensure that as a country, we are a country that respects and upholds the rights of indigenous people in Kenya. The Commission also participated as a member in the task force that I had just spoken about, that had been appointed to advise on implementation of the decision of the African Commission on Human and People's Rights, and more recently also participated as a member of the task force that was appointed to advise on implementation of the decision of the African Court on Human and People's Rights in the Ogiek of Mau, in the Ogiek of Mau case. For that later task force, it finalized its term, compiled a final report that was shared with the appointing authority, being the Ministry of Environment and Forestry, sometimes in early 2020. Unfortunately, today that report has not been made public, despite various requests by especially civil society organizations that are supporting indigenous communities in their demand for the realization of their rights. This implementation and the role that the Commission and other civil society actors have played has not been without challenges. I will not go through this because the previous speakers have spoken to most of the challenges. I will only highlight one, which is the lack of political goodwill and commitment towards implementation of the Commission decisions, as well as the decision of the African Court on Human and People's Rights. Despite the various calls to the government of Kenya to implement this decision, despite even the passage of a resolution, despite a visit by the working group of the African Commission, nothing much has been done, as I have already highlighted, in terms of actual implementation of the decision of these two regional human rights mechanisms. Finally, as I wind up, I will just highlight and give just a few recommendations, speaking to where the NHRI and the civil society actors should work together. First is to remain vigilant, demand accountability repeatedly, and hold the state to account for implementation of these decisions. This is more of general advocacy for the respect of the rule of law, because you would appreciate that more and over and above the two decisions, our local domestic courts had also pronounced themselves on these matters. The Endorois, as well as the Ogiek cases, have been the subject of litigation before the domestic courts in Kenya, and especially for the Ogiek, we have favorable decisions that have not been given effect to date. The NHRI and other NHRIs broadly, and jointly with civil society organizations, should continue to challenge any continued violation of the rights of indigenous people, and where possible, actually support or facilitate access to justice by indigenous people. I have in mind some cases that are already ongoing before our domestic courts. And actually, these cases are facilitated and heavily supported by civil society organizations. In one case, the Ogiek of Mau are challenging the actions of the state towards implementation of the decision of the African Court on Human and People's Rights. We also have another case filed by the Ogiek of Chepkitale, who are seeking similar orders to what the Endorois and the Ogiek sought before the African Commission and the African Court respectfully, being recognition of their ancestral land rights, which facilitate a number of other rights, such as the right to practice religion and observe various cultural practices. We also have the Sengwer of Mbobut Forest, who have a matter currently pending before the Court of Appeal and are actually supported by local civil society organizations. To the extent possible, the civil society organizations and NHRIs should support and facilitate dialogue between the state, indigenous people, as part of the solution seeking, and ensure that especially the indigenous people as victims of these violations participate meaningfully in these processes. I am glad and happy, and I can actually commend the civil society in Kenya for their very active engagement with the Ogiek Task Force when it was discharging its mandate to render an advisory to the state. The civil society not only organized and facilitated the participation of the indigenous people, but actually attended sessions and made submissions on behalf of the communities that they represent. Again, they should also continue coordinating and strengthening national efforts towards implementation of these decisions, and I am happy with the efforts that have been taken to organize this forum to actually discuss and chart a way forward on what best could work or could be done to ensure that the rights of indigenous people are given a practical effect. As I wind up, NHRIs and CSOs should jointly and continuously champion and advocate for the ratification and implementation of relevant international human rights instruments. There are different instruments that codify the rights of indigenous people that we have not ratified, and many other countries have not ratified, and efforts towards ratification and implementation would be very, very key. Finally, as I wind up, the progress so far realized in the enjoyment of human rights broadly and on the rights of indigenous people specifically is largely and greatly attributable to the efforts of the civil society and the NHRI as well as other actors. Working jointly is a way to go. Justice and human rights matters are way too serious to be left to judges, advocates, and NHRIs and civil society actors alone. I would stop at that and possibly take any questions if the opportunity presents itself. Thank you very much.
Thank you so much, Cyrus, for that eloquent presentation on the role of the NHRI. Really also laid out the case for collaborations and networking between NHRI and civil society towards implementation. Thank you a lot. That brings us to the end of the presentations. Now, I would like to open up the floor to the plenary for questions, comments, elaborations of strategies from different actors who are represented here. In the meantime, maybe I could invite Faye to give us an insider perspective of the African Commission experience in dealing with this case and drafting the decision.
Thank you very much, Jafet, and thank you very much, Andrew, and also to Janet. As I said before, this is a decision which, for me, is quite close to my heart. When we were drafting this decision, and I mentioned in the comment that we should give some praise to Justice Sanjay Monahan. She was the officer, or she was the commissioner in charge of the communication. And we did so many drafts, myself and Dr. Eno, we did so many drafts. And then she reviewed it, and she was never satisfied until she said, I wanted perfection in this case. Because for two reasons. The Endorois community were always at the session, always. And we had a series of meetings with them. And at one point in time, we went to Kenya. So we had a view of what was going on. And she saw this as an example of a case, I think, where the commission could make a difference to the lives of people. So whatever I said about the Endorois case, we must make mention of the chairperson by then of the African Commission, Justice Sanjimonia, and also Dr. Eno, who was the supervising officer. I was the lead writer and Dr. Eno was the supervising officer. So we must make mention. But another thing, I must congratulate and commend also the Kenyan government. It's a very odd thing for me to say, but they collaborated and cooperated throughout the process. When we requested submission of documents, they were ready to give. They were always at the session presenting their own side of the story. And so again, even though it was a contentious issue, and even though the judgment went against them, I must congratulate the Kenyan government for agreeing to the process. However, I have a question, and I have a question for the Kenyan National Human Rights Institutions. I simply don't understand how the Kenyan government would have collaborated all throughout the years, and 10 years after, they have not been able to implement many of the decisions. I simply don't understand it. And the question I have for the Kenyan government, and I suppose for the representative of the Kenyan National Human Rights Institution, is what is the problem that is stopping the Kenyan government from implementing this particular decision throughout in all its entirety? What they've done is to implement patches of it, which to me is quite disappointing. And Andrew mentioned it, and even Japheth. When you look at what is happening within the African human rights system, slowly, our state parties are eroding many of our rights. Take like the courts. Some of the people who were already part of the courts are removing themselves from the courts. And until we put the feet of their state matters close to the fire, probably will not be able to get much joy. My recommendation is, I think, and the representative of the National Human Rights Institution says collaboration. But we've been collaborating as members of the civil society right now. We've been collaborating for a long time. So we must come to a conclusion of this matter. What should be done? Should we go to the African court or should we take it further? But because collaboration has not worked, up to now, the Kenyan government has refused to honor their obligation entirely. So I suppose maybe the Endorois community and people like us now, Japheth, Andrew, we should sit together and say, what should be done to hold the Kenyan government accountable to the standard which it has set for itself? Thank you very much.
Thank you so much, Dr. Faye, for that comment and an insider view, but also for the question. I'm seeing one question from Emily Rosa. I don't know whether you want to verbalize this question.
All right, so my name is Emily Lerosion from Laikipia North. And my question is to the Endorois community leaders. While you are pursuing plea for the right for your land, how was the experience? Did you face any challenges or threats from the government now that you took a step of going to the African Commission? And were there any threats of also leaders being convicted or being killed? Was it something that was stressing the leaders from accessing these rights? Because in Laikipia, we have same issues. People are being displaced, and mostly the leaders around or the human rights defenders tend to take a step back, maybe for fear of being harassed. So how was that experience for you leaders from the Endorois community? Thank you. Should we begin with you, Cyrus?
Thank you for the question. I'm actually at a loss. I'm in a very hard position. I cannot speak for the government. I really also acknowledge there's a problem. I would be the most happy if much more could be done to bring the government to account and for it to especially give effect to what it committed to by ratifying some of these instruments. But broadly speaking, I would say that lack of political goodwill has been a very big challenge. And not just that, the entire question of respect for the rule of law. Because it's not only this decision, we also have other decisions by the local courts that have not been given effect. So I very highly welcome the idea of maybe having a strategy meeting and thinking through what is it that can be done more, because we've had this discussion for far too long. For actually over 10 years, the community has been waiting. The Ogiek are waiting. And there are many others in the country that would have gotten a lot of hope if these decisions were given effect. Having said that, I would identify the lack of political goodwill and maybe a question of lack of respect for the rule of law as the most serious challenges to the implementation of some of these decisions, and not just decisions of the regional mechanisms, but also decisions of the local domestic courts.
Okay, thank you. So I was just going to touch on that aspect of implementation and agree with Cyrus that at the heart of it, it's a question of political will. But just to unpack it a bit more, I talked about the transitional moment that Kenya had gone through and the wide array of reforms that Kenya had experienced, primarily post-2008. The signature marks being the 2010 Constitution that encapsulates a whole broader array of Bill of Rights that Cyrus mentioned, recognizing even the rights of indigenous peoples, but also opening up the arena for a reconceptualization of Kenya's land tenure systems. We now recognize community land as one of the key pillars of our land tenure system, and also setting up pillars of what I would call pillars of accountability, not just the National Human Rights Institution, but other independent organs like the National Land Commission and the Commission on Administration of Justice, or the Office of the Ombudsman. Now, one would think with all this reform and this landscape of independent institutions that then, like Dr. Fay suggested, we would logically move towards a government stance that embraces reform. But then you have to look at the context and appreciate that within Kenya's prevailing political economy, one of the most tenacious issues that has even survived this reform effort is the land question and the difficulty of unraveling the land question. There is no denying that there is a lot of vested political interests in the land question. This is one of the areas where political power and capital ownership fuse into this very dangerous situation where duty bearers are also, in a way, perpetrators. And so it becomes very difficult for them to either legislate or action against their own benefit. And that is what has held back cases like the Endorois case. The fact that there are still forces within the state that are intent on undermining or slowing down the process of comprehensive land reform that can then realize the objectives of things such as the Endorois case decision. And that's why I mentioned that the aspect of maintaining that element of struggle is essential within the community, but also within the arena of civil society, that they must then view this current context as one whereby what you have is an expanded platform of pursuing the advancement of rights, like I mentioned. So you have all these new independent commissions that you can innovatively utilize. You have a refreshed judiciary, and you can explore the boundaries within which you can push some of these issues, even though we note there are decisions that have not been implemented, as Cyrus mentioned. But it's about how we continuously explore those spaces and continue to look for opportunities and tides of reform to push the agenda forward. So in essence, what I'm saying is reforms did happen. They lend themselves to an operating framework that can advance the implementation of decisions like the Endorois, but the prevailing political economy dynamic is still very much one that is contested and one that has drawbacks of reform versus forces of reform. And we have to be alive to those elements as we look to engage. I will quickly then conclude this part by just mentioning that there are examples of innovatively trying to use these spaces. So I would say it's kind of like, you can characterize it as progress, inertia, and regression happening constantly. Just to give an example, when I mentioned, Cyrus mentioned the task force on implementation. One of the interesting things to note of how we got to that task force is, after the implementation hearing at the African Commission, and the resolution was passed against Kenya, there was still relatively muted silence by the Kenyan government. So we did have some of these strategy sessions that are being proposed here as people concerned with the Endorois case. And one of the questions we asked ourselves is, how can we trigger the impetus or action? And one of the innovative things we did was we then framed the resolution and the lack of action by the Kenyan government on the African Commission resolution as a matter for the Ombudsman to deal with. That we reported the Office of the Attorney General for failing to act on a decision that had been issued by the Commission and a follow-up resolution that had in fact indicted the state for failing to implement the decision. The response was that the Attorney General then wrote to the Ombudsman and undertook to then take up that resolution. And very soon after, we had the gazettement of the task force. So one of the lessons we learned very quickly there is you can innovatively use some of these expanded platforms that came with the reforms to try and nudge the needle forward. The National Land Commission was another opportunity. They had an aspect of investigating historical land injustices. This called the Ministry of Lands to account because the Endorois were able to table the decision and ask hard questions of the fact that nothing had been implemented. And so even the National Land Commission in its report on historical land injustices highlighted that aspect. And it's what again kind of fed into the reinvigorated joint task force that was supposed to deal with the Ogiek case and other indigenous people's land rights. So this is just to create and highlight that there's a climate of contestation, and what we need to do is have a sustained engagement and continuously to innovatively explore the spaces that exist. Thank you.
Thank you, Andrew. I think Andrew has really hit the nail on the head, that really at the core of the issue here is the emotive contested issue of land ownership in Kenya, and also describing really the status in three ways, as representing inertia, progress, and regression all at the same time. I think that's really a very articulate way of seeing the status of compliance of the decision. Janet, Emily had asked a question about whether you faced any harassment by the government in filing the case.
We had a lot of embarrassment, especially men's, people who are working in the government. They were forced to stop working. They were beaten. Even some of our houses were banned by the government. There was a lot of problems, actually. The struggle was not easy. Yeah, we faced a lot of challenges in the community that during the struggle. It was concerning our land rights, so that we decided as a community to take our issues to African Commission, just because of the failure of the government. Let's say Kenya government failing to hard on us. Actually, they were doing injustices to our people or our community.
Thank you, Janet. I just want to give, if any panelist has final words to say.
There are two planes on which you can look at the status of implementation of the Endorois case. And how we went into it. So to begin with on the first plane, if it's about the material benefit that has accrued to the Endorois community, I think that is where you will find the major challenges, and Cyrus walked us through that extensively. The key goal of acquiring title to the ancestral land for the Endorois remains an ongoing concern or an ongoing challenge. The issue of true compensation remains an ongoing challenge. And so that element of the material benefit for the Endorois, while there have been some small concessions with regards to revenue sharing and employment, the material benefit for the Endorois is still substantially a challenge. On the second arm of the objectives of the litigation, which was to positively affect the policy, legal, and public attitude environment for the Endorois and other indigenous peoples. Again, as Cyrus highlighted, you have a lot of elements of progress you can point to in terms of, has the legal framework fundamentally changed in favor for the recognition of indigenous peoples? Yes. Has the legal framework fundamentally changed in favor of the recognition of land tenure systems as understood by indigenous peoples? Yes. Have there been frameworks or initiatives that have been aimed to investigate or to understand the historical injustices associated with the experiences of indigenous peoples in the country? Yes. But what's the overall challenge? The overall challenge, even within this massive improvement of the legal and policy frameworks, is the operationalization or actualization of those frameworks to the benefit of the communities. And so again, here is where now the challenges begin to play out. We are now in a space where we can finally say that after a long wait, community land tenure systems are being operationalized. We have experiences of communities finally getting to register community land title, which is a very positive development that we hope continues to go on well. But it has happened under a space of some significant challenges, some communities not being fully informed of the process or understanding of the process. So a lot of public education will need to happen to actualize community land title effectively. I think one of the biggest missed opportunities has been the fact that we had a space in time within the law through the National Land Commission to build on what the Truth Commission did and effectively investigate and prescribe remedies for historical land injustices. Unfortunately, when the National Land Commission issued its report in 2017, it was a very muted affair, and not much has been said about how to deal with the historical land injustices that the National Land Commission identified and the recommendations they made. So that remains a hanging question. And then there's also the lived realities of the communities even today, that despite the framework of rights that exist, despite this robust constitution that we, in our current context, may be revisiting to amend, despite the rights that exist, you still have ongoing violations that can be spoken about, and Cyrus mentioned them quickly. So like the Ogiek continue to talk about fear of evictions, the Sengwer communities continue to talk about fear of eviction, and even the Endorois have continuous ad hoc episodes of harassment from the state. And so that also suggests that the existence of the framework in itself does not guarantee the protections it describes. And so that's why I will end with, again, what I concluded with. We need to take stock of the assets we have acquired over the last 10 years in this fight for indigenous people's rights. And I think the key assets are the communities are more aware and empowered than they were in 2003 when this case began. You have civil society organizations that are specialized from the communities. You have leading activists. You have leading lawyers from indigenous people's communities who can continuously take up this mantle at all levels. You have networks that have developed and allyships that have developed. The communities did not do this alone. Kenyan civil society did not do this alone. You have friends and partners across the divide and issues that can galvanize us all together, whether it's the question of climate change, whether it's a question of rethinking conservation policies. You do have networks that can grow this movement and strengthen it towards implementation of this decision and the wider rights. And finally, to emphasize again the importance of generational transfer within these communities of the struggle. They need to incubate leadership to sustain the understanding of the claim and the assertions of the communities, so that you maintain that aspect of clarity, you maintain that aspect of cohesiveness, and you maintain that aspect of resoluteness in the cause, until we can talk about a day that indigenous rights or indigenous people's rights are not just articulated, but they are asserted and enjoyed by the communities. Thank you.
Thank you, Andrew, for those final words.
My final words would be that matters justice are a concern for everyone, and we should be more concerned about access to justice, especially for the vulnerable, and the indigenous people actually represent these disadvantaged group of persons. So let's all support them. Let's do the best we can, whether it's advocacy, whether it's actual litigation, whether it's actual capacity building for the indigenous people. Let's support them to the extent possible to ensure that they live in an environment that protects and respects their rights.
Thank you, Cyrus. And then I think Janet is not in. So that brings us really to the end of the side event. Thank you so much, Andrew, Cyrus, Janet, for very insightful, very elaborate and comprehensive discussion on Endorois' decision 10 years later. Thank you and a good day.